attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, practicing attorney. Happy New Year to everyone, and the law office is open 2021. And if you have a legal question, all you have to do is dial the toll-free number, which is 877-943-9673. 877-943-9673. And phone lines are open. Hey, if you have a legal question, it can be about anything. It can be about wills, trust, probate, guardianship, power of attorney, healthcare surrogates, living wills, family law, real estate law, just about anything. Some problem. Doesn't even have to be a legal question, just a problem you might have. Again, I'm attorney Joe Pippen, host of Ask an Attorney, all about Florida law for over 37 years now, 37 years in running, and we are here to help you. You're listening to a live show, actual talk radio, live show where you can call in and ask legal questions. Your question hopefully will give you a little peace of mind, point you in the right direction, but also help a lot of other people who might be listening to the show. And again, toll-free number if you have a question is 877-943-9673. So one of the questions that came up in the practice this week dealt with who should be the trustee. You know, often in a marital relationship, there is one person who handles the finances, one person in control of the estate, one person who writes checks, deals with taxes, deals with investments. You know, there's one person that's usually better at doing all that and has done it for a long time. The other one just kind of sits back and lets all that happen. Well, you know, unfortunately, a lot of times the person who handles things dies first. And then that leaves the other one, you know, in a little bit of a hard spot. So that comes into play on how you do estate planning somewhat. Because if the person who's left behind is not the one who feels comfortable writing checks, dealing with finances, dealing with investments, who should that trustee be? So it can be, you can do, if you own all of your assets jointly, which is commonly the case also, particularly in a long marriage, and the one who handles things dies first, well, you can create both people creating the trust to be grantors, and the grantors get to pick who the trustees would be. So let's say the one that handles the assets the most should be maybe the sole trustee instead of joint trustee. And then if that person who's mainly used to handling things dies first, then another person can be the trustee for the one that's surviving in their total benefit. So there's a lot of different ways you can do estate planning. That's certainly one of them. Let's go to Jeff in Hudson. Hey, Jeff.
Hey, how are you doing?
I'm doing good, and you?
All right.
What can I do for you, Jeff?
Got an issue with the divorce.
Okay.
I've got a stimulus check that I just received that was made out for both of us. And I got a no contact order with my soon-to-be ex-spouse. And every time I talk to my attorney, it costs me money. So it's going to cost me $267 to get $600. So I'm wondering what I can do.
Okay, so you cannot contact your wife. You cannot have any phone calls with her or any personal contacts with her.
Exactly.
Does she have an attorney?
Yeah.
And your attorney charges you for every phone call and everything?
Yeah.
Okay. Does your attorney charge you for text or email answers?
Well, I've texted him on other checks that I've received that were made out to both of our names. Not got response on those either. So basically, that kind of all went into the settlement where she got some upfront money from me. That's what I'm believing. It's not stated that in the court document. I just paid her $5,000 to be done with this in mediation, and the final hearing is on Groundhog's Day. But now I got this check, and she's already got my IRS money from the refund last year and the first stimulus check. So I'm like at a loss. I'm like, damned if I do, damned if I don't.
Well, if you had is there a final divorce decree issued?
No, there has not been. The hearing has not happened, no.
What I would do is just send the attorney a copy of the check. Let him deal with it on your inventory you have to do, and deal with the other attorney on how everything's get split.
Okay. All right.
You know, that's,
Makes sense.
Yeah, you have an attorney. You probably have a contract with the attorney about the fee agreement. I don't think you really need to discuss it with him. I think you just need to send him a copy of the check so he can deal with it as part of the inventory and how everything gets divided.
Okay.
All right. That would be
I appreciate it.
That would be the next step, I think. All right, thanks. All right, you're listening to Ask an Attorney all about Florida law. Again, I'm Attorney Joe Pippen, practicing attorney. The law office is open. You have a toll-free number, which is 877-943-9673. 877-943-9673. Phone lines are open. Be more than glad to try to help you in this new year any way I can. The sole purpose of the show is just to help as many people as I can during my 52-minute straight run with no commercials. We're here to help. 877-943-9673. Phone lines are open. So that makes me think about what would happen if a couple had a joint trust and one of them and they go through a divorce. What happens? What happens with the joint trust? Well, you get the assets all divided up into separate names. So when you leave the marriage, you have separate assets, and then you each need a separate trust is basically the answer to that question. Let's go to Anita in Jacksonville.
Good morning.
Hey, Anita.
I have a child support question, I think, is how it's going to be based. I have my son. Me and his father was not married. We split up about 2 years ago come March. He came up with an amount to pay me, which is like $500 a month, but not putting my child on medical. And so I'm trying to find out what is the law as it pertains to, who should have medical care on a child in the state of Florida.
Okay, so you never went to court. You never got child support through the court system. Y'all just made a little personal agreement between yourselves.
No, we didn't make it. He made it. And I had been through so much, just didn't want to keep going through it. And so, he cash apps me the money every week, and I just accepted it. But I'm at the point to now it's not enough. And I'm wanting to know, if I go, through the courts. I even asked him, I said, if you get medical, I'm fine with the amount that you're giving me, but he's not wanting to add my son onto his medical, and it's costing me more money.
He gives you $500 a month?
Yeah. Yep.
Well,
makes way more than that because he has rental properties that he rent out rooms. Like I said, he's married now. He makes way more than that. The $500 is nothing to him, and that's why he threw it at me. But I'm just not even wanting to argue and fight about the money.
Mm-hmm.
It's like just wanting to know, what are my rights, as it pertains to medical for my son.
Yeah. Well, Anita, my suggestion to you would be if you need help finding an attorney there in Jacksonville, I can give you a referral for a family law attorney in Jacksonville.
Can you do that?
Yeah, but can you send me an email? Then I'll send an email back with a name for you.
Okay. I'm actually on my phone.
I'll give out my email out. It's just Joe, Joe, at attorneypipp.com. And I'll be glad to get you. In most family law, then the family law attorney I think will give you a free consult.
Okay.
And then they can advise you what the cost would be and what they think they can do for you.
Okay, let me repeat that back. I'm not sure if I got it right, Joe. You said Joe at attorneypipp.com?
No, P like Paul, IP like Paul. The first three letters of my last name, Pippen.com.
Okay.
attorneypipp.com. Those are P's like Paul.
Okay.
All
I'll
right?
go down and see you. Thank you so much.
All right, thank you. All right, you're listening to Ask an Attorney. That's me, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. Name of the show is Ask an Attorney, and all you have to do if you want to talk about a legal issue or maybe get some legal information to get you pointed in the right direction is call the toll-free number, which is 877-943-9673. That's 877-943-9673. Hey, we are broadcasting live right now on Facebook. We're broadcasting live video on webeamtv.com. If you would like to watch the show, sometimes those are every other week we broadcast live on Facebook and webeamtv.com. Webeamtv.com also has a variety of shows on their network, and this is one of them where you can easily go to and watch. Also, we have our own YouTube channel that Ask an Attorney. We have, if you have an iPhone, we have an iPhone app, Ask an Attorney, where you can listen to previous shows. We also will slice up this show sometime during the week and pull off different questions and replay the individual questions on Facebook and LinkedIn and some of the neighborhood sites and things like alignment and things like that. We broadcast. So if you're into media, social media stuff, you might even hear your question on one of the formats we presented on. Right now, though, you could call the toll-free number 877-943-9673. 877-943-9673. That last question prompted me to think about what to do with minor children in estate planning. A lot of younger people don't think they have much, and they don't worry about estate planning as soon as they should. But really, when you have a young child, it's very important. You get to name who the guardian of the child would be. Now, in this last case, Anita, she did an estate plan, for example. She might not think her husband would want the child to live with the child, and so she should appoint maybe an alternate guardian if he's not willing to continue raising the child. And then it comes into sometimes proving that's his child, and sometimes you have to do the test to determine who the father is, and sometimes that becomes an issue. Sometimes the father's name's on birth certificates and sometimes is not. But even if you're married and have a couple of children, who do you want the guardian of your children to be? And you can't leave children money directly from life insurance and annuities and pension and retirement plans. So that money funnels into a trust, and then the children get the money at age 21 or 25, and someone manages the money for their benefit all during that time period. A lot goes into estate planning, and you really should have estate planning if you're a minor child. And if you're a grandparent and you're worried that what happens to the grandchild when your child dies, you need to encourage them to do estate planning. They might have even named you, the grandparent, as a guardian. And do you want that job? It's always important to have contingent guardians named in estate planning as well. All that's very, very important for you to do if you have minor children, and estate planning is to plan for it. And, this is in the first live show we did once in a while. Once in a blue moon, I'll do a repeat show, a best of. We did that last week. And I think that was the only week we did last year, a whole year. 51 weeks we did live shows. We did one repeat show. This is our first live show of 2021. And so we're here every week to answer your legal questions. Again, phone lines are open right now. We'll be more than happy to help you. You have a toll-free number, 877-943-9673. We're already almost a third of the way through the show. So if you have a question, don't be shy. Get a little information. A lot of times on the first part of the year, I do a show on New Year's resolutions, on things you should, I know everybody wants to lose weight, get in shape. Really should get your financial planning and your estate planning in shape. And it needs to be reviewed. I suggest review the estate plan every 3 or 4 years and take a look at things and make sure nothing just changed and everything's just the way you want it. If you want to add somebody, delete somebody, change how they get their money, distribute it to them, all of those things. If you have beneficiaries on accounts, retirement accounts, insurance and annuities, all that needs to be looked at, reviewed, make sure all that's going to work the way you want it to. And what a better time than the first of the year to make a resolution to get your estate plan or financial planning all in shape and in order this year, 2021. Again, I'm Attorney Joe Pippen. You're listening to Ask an Attorney all about Florida law. If you have a legal question, the phone lines are open. You have a toll-free number, which is 877-943-9673. Let's talk about retirement accounts and estate planning and how those things relate to one another. Well, first of all, if you have a retirement account, most likely you have a beneficiary. If you have a beneficiary, that avoids probate, but then that person can take all the money right at once. If you don't want them to take it all at once, then it should come into like a trust that has provisions in it to avoid any tax implications and to be able to have the money pass out over a period of time. Let's go to Nancy in Sarasota.
Good morning, attorney. Thank you for taking my call. I have two questions. The first is, I'm building a house with my partner. We're married, and I'm calling to ask how we go to obtain a deed and put both of our names on it. Is that through the city, or how is that done?
No, an attorney would do that for you. So whose name is the property in now?
It's in my partner's name. He bought the land like 15 years ago.
Okay.
And the house is...
Yeah, so most likely you just do a quitclaim deed from him to both of you.
Okay.
Now, so you're not married?
No.
Okay. So he would need to know that the property needs to be appraised.
Appraised?
Mm-hmm. And then the value of the property would be treated as a gift because you're not married. So, and then he has to determine whether it's going to be jointly with right of survivorship or tenants in common, where you each own half. Your half would be treated as a gift. So let's suppose the property is worth $300 and it's free and clear of a mortgage. So he's made a $150,000 gift to you, and he can only give away $15,000 per year without reporting it to the government. So
I'm sorry.
He'd have to file a gift tax return. He doesn't have to pay a gift tax because he can choose to use up part of his lifetime exemption, which is $11 million.
Okay. We were thinking of putting both of our names on the deed to avoid all of this. Is that possible?
Putting your name on the deed is a gift to you. So
my name on the deed is a gift to me.
Yes.
We can't just do a deed.
Well, he does it with a deed, but doing it, the only way to get your name on the property is a deed. He's going to give you half of the property. That's a gift.
Okay. Very good.
So an attorney would be glad to go over all that to you in person that does real estate deeds, and we do, by the way, and we have an office in Lakewood Ranch. But that's the...
you do?
Yeah.
So wonderful.
So we'd be glad to sit down with you and help you, and all you have to do is call the office.
Very good. And then I'm also looking for a trust to avoid probate.
Yeah, well, The estate chain, if you wanted to, people from Sarasota that want to see me, come to the Sun City Center office. People that want to stay in Lakewood Ranch and see our attorney, that would be Attorney Dennis Moses, handles that office. And he's done lots and lots of deeds and lots of trusts, so he could help you as well. So.
Okay, and you're in Sun City?
Yeah, I go to Sun City once a week, usually on Wednesdays.
Oh, okay, very good. All right, I'll make the appointment. Thank you very much.
All right, thank you.
Okay.
All right, you're listening. You ask an attorney all about Florida law. Again, I'm Attorney Joe Pippen, practicing attorney. The law office is open. You have a legal question of any type, you have a toll-free number, 877-943-9673. Now, just to go back and add something to that answer, if you're married and you want to, and a real piece of real estate is in one name, and you put it, now you want to own it jointly as husband and wife, you still need a deed. You still do a quitclaim deed, but there's no gift tax implication. There's no appraisal or gift tax implication deeding it to a spouse. There's only a gift tax implication if you're not married and you're putting someone else's name, a child or a partner, you're putting someone else's name on the deed, then that's a gift. You can only give away $15,000 per person without having to file a gift tax return. That doesn't mean there'll be a tax involved, because you can elect not to pay the tax and use up part of your lifetime exemption. Right now, your lifetime exemption is $11 million. Let's go to Steve in Orange Park.
Hello?
Hey, Steve.
How are you doing, sir?
I'm doing great, and you?
I'm doing well. I have a question about alimony. I'm one of the few that I actually get alimony from my ex, and we've been divorced 10 years now. Her alimony ends in, I think a little over 3 years, but she's 5 months behind. I just want to know what my rights are as far as trying to get that, and am I out of line to call her and ask her to pay that?
Oh, not at all. Not unless there's some restriction on you calling her. But sure, call her.
There's no restriction. Okay, well,
you can you can sue if she's back on alimony payments. You can go into court, if you have a family law attorney, and get the court to give an order for her to pay. You can
right.
You could do that. You could file a lawsuit, get a judgment against her to protect what she owes you. There are several options you have. If you have a family law attorney, I would discuss it with them, though.
Okay, and you did say that I'm okay just to text her and say, would you please make a payment? I mean, that's not out of line, right?
No, not at all. I mean, she owes you money, so.
Okay, see, I've never had to actually do that. Paul, was it Paul? That's right, Paul.
My name's Joe.
Joe, I'm sorry.
All right, no problem.
I just feel like sir?
No, it's no problem. So yeah,
but,
go ahead and call her and text her and ask her. You haven't made your payments, so what's going on, and can you pay me? And
right.
If you're not going to pay me, let me know, and I'll go from there and do what I have to do.
Okay.
I mean, I'd be nice about it, but okay, all right, thanks.
Well, yeah, I'll be nice. I mean, I hadn't even called her about it, so I appreciate it. I think that's really what I needed to know.
All right.
I mean, I knew I could go see a lawyer, but I really wanted to make sure that I could call her. That was really my main question.
Yeah, just tell her
about it.
Tell her you're concerned that she's okay. She hasn't made the payment. You were concerned about her, and and then if she's okay, why she hasn't made the payment. See if she'll give you an explanation.
I appreciate that, Joe. You have a nice day.
All right, thanks. All right, bye-bye. Phone lines are open at 877-943-9673. Let's go to Bernard in Jacksonville.
Hey, Joe.
Hey, Bernard.
We have a trust set up for our property, and we have, actually my wife has a handicapped daughter who we did not include when we set the trust up because she currently resides with her father, and she's, 40 years old. And I'm wondering, is there a way that we can include her in that trust that she would get the money and nobody else? How is that possible when they're not able to, take care of their own affairs?
Yes, sir. What that would be called would be putting a provision in your trust for a special needs person. So basically, the money would be setting in your trust, controlled by the trustee that you pick to control the money in your trust, and it would go out to your special needs or your wife's special needs child, but it's controlled to not. It can't be distributed if it would interfere with any government benefits she would be entitled to.
Okay.
So it's called a special needs trust, basically.
Now, you said that would cause her not to be eligible?
No,
right now she's getting...
Yeah, no, you draft a document so the distributions to her from the trust would not interfere with her government benefits so she could keep them.
Oh, okay.
And this is a special needs trust that can give her money to the extent it doesn't not interfere with any government benefit she's entitled to.
I got you. So we could make her sister the trustee of that one little part of the trust.
Yes, it would just require an amendment to the trust.
Okay, awesome. Well, I tell you, we've been debating about that for months now, trying to figure out how to do it. And I appreciate what you're doing.
Well, if you're happy with the attorney who did the trust, go back to that attorney and see if he'll add the supplemental needs provisions to your trust. If not, I do have offices in Jacksonville. Come there every other week for a few days, and would be glad to amend it for you. But if you're happy with your attorney, I suggest you go back there and see if he can add that provision for you.
Okay. Well, let me kind of a side question. It's still about the same thing, though. In our joint bank accounts, we have, of course, people, if we're not there, they can take care of it. Could we make her through an executor to have part of that as well?
Well, your trust, your bank accounts should be, if you have a trust, I don't know why you would not have the bank account title, your name, your wife's name, trustee or trust with the date of the trust.
Well, she is.
So that puts the account in the trust.
The bank account is in both of our names.
Yeah, but it should be.
We have no. Go ahead.
Should be in both names, trustees, date of the trust, though.
So the bank account should be part of the trust.
Should be in the trust, yes.
Okay. Okay, cool. Did not know that.
Yeah, well, if you have a trust, that's why you put things in it to avoid probate.
Well, of course. But, like we have we have daughters, both of us have daughters, and we put them on the bank account, so if something happened to us, they are signatories on that account, so they could go in there and write checks.
Well, it's better. It's better in the trust because they could be the successor trustee to do the same thing. But if you and your wife were both in a joint car accident and both became incapacitated, they can't get to that money. Right. They can't get to that money, but they could as trustee of your trust for your benefit while you're living.
Okay. Even though they're listed on the account as able to write a check on that account, they still couldn't get to it?
Well, then it sounds like you've made them an owner of the account with signing privileges. Yes. Well, the problem with the trust is better than that because if they get sued, divorced, or have an accident, then their creditors can come get that account that they are also an owner of. So it's better inside a trust. Yeah, it's better inside a trust. I got it.
Okay.
All right.
Well, thank you very much.
My pleasure. Thank you for calling. If you have a legal question, you have a toll-free number. The toll-free number is 877-943-9673. Let's go to Alan in Tampa.
Hello, Joe. How are you doing?
I'm doing great. And you?
Good. Very well. Thank you. My question is regarding a rental property that we just started renting a commercial piece of property from an individual, well, actually from a company, about 30 days ago. And at the time of signing the lease, there were some deficiencies, and we asked them, we went over what needed to be done, and the guy agreed to it. And then, so right after we moved in, we text messaged the gentleman and made sure that he was aware of the 3 things to remind him. So this has been 30 days later. We've texted him 3 times. We decided to email him, and we still haven't gotten anything fixed. And my question is, can I go ahead and, now that he's been notified by email, can I go ahead and just go ahead and have the problems fixed, and then just send him the bill from having the different things taken care of, remediated?
Well, what I think I would do is send him a certified letter telling him if he doesn't fix it by such and such a date, that's what you're going to do, and hold him responsible for it, and see if you get a response that way.
All right, very good. And then one quick question. One of the things has to do with he put up these metal slats over the window, so that's more of a code violation, I believe, and we asked him to take that down, and he has not taken those down. So I would include that in the certified letter, I guess, or should I call the fire inspector for that?
Well, I would call the inspector who's going to, is he licensed, and did he get a permit to do the work?
Who's that?
The person.
The guy?
Yeah.
That owns the property? I doubt it. It looks like it was some homemade job that he did. He just drilled holes and screwed them into the windows.
And you're the renter?
I am the renter, right.
All right. Well, and what's the term of your lease?
2 years.
And when did that start?
It started in mid-December.
Well, you can hold him accountable, but that doesn't mean he's going to pay it, and that doesn't give you the right to diminish your rent payment. So,
for removing the bars, we don't want burglar bars up. We just want them off for safety purposes, because if there's a fire inside of that unit, we want to be able to get out by smashing a window and exiting the place if we have to go out that way.
Well, I'd send him a certified letter that, you're going to hold him responsible if he doesn't fix it as he promised within such and such time, and see what kind of happens next.
Okay, we haven't had any success so far. We've been bugging him, so we're just thinking we just need to go ahead and take care of the problem ourselves.
Well, some of this controls, does the lease address any of this type of issue?
None of it. Well, it does control. One of it is a light that's just not working. So yes, the lease says that it will maintain these, fixtures. And the other thing is, he never gave us a lock to the inner office doors, and accidentally they've been locked twice already. And he did come and have a locksmith, come out and open the door for us one of the times. The second time, he didn't. So anyway, it's just been things that are just.
Well,
I think that
I'd be a squeaky wheel and send him a certified letter and see what happens.
Excellent. Thank you so much.
All right, thank you. Let's go to Charles in Tampa.
The question I'm going to put to you is, legislature is the only body that can change voter law, and it is circumvented. Is that against the law?
All right, what is your question now? The only body that can change what? What?
All right. Voting law.
Voting law. Okay, voting.
Right?
Uh-huh.
All right. So you have the legislature, which is the only body that's allowed to change the voting law. If it's circumvented and changed without the legislature's voting, is that against the law?
Well, I think that's one of the big questions in the recent election, and I would say yes, but it doesn't seem like any court has taken it seriously.
That brings me to my next question.
All right.
Why did the Supreme Court not make a determination on this?
Well, I think it was a question of standing, whether they had the standing to there's a very complicated question, and I don't know all the ins and outs of all the. It just seems like from anyone looking at all this, they tried to go through the court to overturn this and that, overturn elections and so forth, and all of the cases got nowhere. It seemed.
Right.
And I don't understand why all the cases got nowhere. It seems like if all the wrong that was done, that was alleged that was wrong, and they couldn't prove it or get a court to take their view of it, I don't think they did a very good job in presenting it. But it seems like everything they tried failed through the courts.
Right.
And
I just think on face value, bringing it to the Supreme Court would show that what they did was illegal. And
yeah, well, they tried to take the Supreme Court is kind of picky on what cases they take and don't take for various reasons. There are a whole bunch of different reasons and ways to even get the case advanced to the Supreme Court. And they're way too complicated to get onto a show like this to try and answer that question when everybody can look and see that it didn't work. So I can't really explain all the reasons it didn't work. I don't think.
Okay. My last thing I'd like to say though is that I always thought it was supposed to be the truth that the law was supposed to protect, and I'm really now a little disillusioned with our court system. All right, because they're supposed to make right.
Yeah, well, these are strained times in their country, and it's probably a lot of things to be a little unhappy about, for at least half the population. So,
all right, thank you
very much. All right, Charles, thanks for calling. All right. All right, you're listening to Ask an Attorney all about Florida law. We have about 12 minutes left in the show. If you have a legal question, you have a toll-free number, which is 877-943-9673, 877-943-9673. Phone lines are open. You hear some of the talking, some of the hosts of some of the national shows talk about succession. And I don't know, with our country so divided, you think, I don't know, that could be a whole show but I don't do political shows. I'm just thinking out loud here. You think some states are going to start to succeed from our nation and separate themselves out because of the big variety and the way half it's always going to be 51-49%, it seems. And some of these issues are major issues, and it just seems so sad for our country to be in this type of position. Hey, you're listening to Ask an Attorney all about Florida law. You have a toll-free number to call the show, 877-943-9673. Phone lines are open at 877-943-9673. If you have a legal question, I'd be more than glad to help you in the remaining moments. Hey, we did a series of Zoom seminars last year. We had 7 of them over a 14-week period. We're doing them every other week. We're going to get those started back up sometime maybe next week. I'll announce when the first one of it will be this year. If you'd like to get us to send you a link to the seminars, they concern living trust, they concern probate, they concern Medicaid, they were on family law, they were on gun law, they were asset protection. If you'd like the link to any or all of those, send me an email, and I'll be glad to forward that to you, joe@attypip.com. Let's go to Courtney in Plant City.
Hi.
Hey, Courtney.
Hi. Hi, Joe. I was actually just listening to you on the radio.
Well, thank you.
Hi. I actually have a question. I'm a renter right now, and I have an issue with my landlord. I recently my lease ended, and he allowed me to go to month, and he said that he wanted to up my rent, and I said, sure, send me a lease, and he never sent me a lease, and I've contacted him 3 times to send me a lease, and so currently I'm living off lease, and I still paid my month of January, for my old rent out of good faith. But I'm not sure what legal ground I have right now since I'm technically living off lease.
Well, you are a month-to-month renter, so.
I haven't signed anything.
Yeah,
He
so
hasn't
that's
sent me anything.
until you sign something, you're just month-to-month.
Okay.
So anything verbal on real estate really doesn't work. So if you want a lease, or if he wants a lease, and you all both want a lease, it's got to be a signed document.
Okay. So I can just email him a signed paper saying I agree to.
Well, I got an email just a couple of days ago. The person had a written lease, and the landlord tried to get him to renew it, and he only wants to be there, 1 or 2 more months before he moves, so he didn't want to bind himself with a lease. So, I mean, some people want leases and some don't. So do you want one?
Not particularly, I guess.
Well, just go with a month then. If you don't really care. Well, a lease gives you more security that you'll have a place the next year. But if you are thinking about moving and you don't want to commit long term, then you'd be better off without a lease, basically.
Okay. All right. Good to know. Thank you. I appreciate that.
All right, Courtney. Well, thanks for calling. You're listening to Ask an Attorney all about Florida law. We have 7 or 8 minutes left. The toll-free number, if you want to call the show, is 877-943-9673. Let's go to Z in Clearwater.
Hello.
Hello, sir.
Yeah, good morning.
Good morning.
I have a question, please. My question is, let's suppose you bought a piece of property, just an example, for $5,000.
Hey, we don't have very good voice quality here. Are you on a speakerphone? There seem to be background noise.
No.
Is there anything on in the background?
No.
Okay, well, go ahead. We'll work through it.
Okay. Let me say someone buy a piece of property, just an example, for $5,000. When the person that sold him the property recorded the property that I paid $1,000. Is that legal?
So you paid $5,000, but they only paid stamps for a lesser amount?
Yes.
No, I don't think that would be proper.
Okay. What would be my avenue?
Well, you could ask him or her why they did that, number one.
Yes.
And if they were trying to save themselves money through an improper method, you tell them they need to correct that, or you'll report it to the county.
Okay. Is that considered fraud?
Well, yes, in a way, yes.
Okay. Okay.
So ask them why they did that and see if they can justify it somehow. See what they say.
Can I go to the county and say, this is what I paid, and this is what he did?
Well, you could, but I would give him a chance to explain first.
Well, I did, and the response I got is, take me to court.
Well, it's no loss to you. It's just fraud on his part. So if you want to do that, then do it.
I mean, can I get my money back?
So you paid $5,000 for the property. He deeded you the property.
Yes. But he recorded that I paid $1,000.
Well, do you have a contract?
No, I have the property. I don't have no contract.
Well, you're not out. So you're thinking the cost basis shows up for you paying $1,000. It should be $5,000.
I tried to sell the property.
Yeah.
The reason I tried to sell the property, somebody said I would like to buy your property. I said okay. They said, "What are you asking for it?" I'm asking $7,000. He said, "You only pay $1,000. How can you sell it for $7,000?"
Well, you can go down to the court and tell them you need that to correct it. But if you don't have a written contract to show them, there's just a verbal offer.
Yeah, a verbal offer.
Do you have a copy of your $5,000 check?
I'm sorry? Yeah, I have a check. No, it was a check. I have a check.
You have a canceled check?
Yes.
All right, we'll take that down to the courthouse and show them. No, he probably did it to save himself taxes. So if you have a canceled check, go down and show the court the canceled check and tell them you like that corrected on the records and see what happens.
Yes.
All right?
Sure.
All right, Z, good luck to you. Let's go to Ed in Tampa.
Yes, hey, Joe. I have a question regarding an executorship, I suppose. My father passed away 20 years ago, and my mother and father were separated. So he left his estate to a trust, and the trust was to be for the purpose of taking care of Mom until her death, after which the remaining monies would be dispersed equally among his children. Well, we've come to that point, and Mom has passed. And as executor, there is residual money left over. Can I simply divide it equally among the remaining children, make a disbursement, and does that dissolve the trust?
Yeah, once all the money comes out of the trust, it's dissolved. Just make sure there are no creditors and no tax bills to be paid, because you as trustee would be liable to make sure everything is tidied up before you make a final distribution.
Okay, that's as simple as that. So, yes, there are no loose ends or strings. Okay, so I don't really need to see an attorney to end it or close it.
No, there's no formal closing through the courts or anything of a trust. That's one of the advantages of a trust. So,
yes.
so
One of the dangers.
Yeah, a lot of times what I do when I'm representing someone like yourself is I send everyone, you would come in, give me copies of everyone's check. I send copies of the checks out with a copy of the trust to the beneficiaries, get them to sign a release and acceptance of that money, releasing you from further duties as trustee. So, you could be a little bit more formal, but if you want to try loosey-goosey and do it that way yourself, that's your choice. Sometimes it's better.
Well, I did prepare a release agreement that clearly states the amount paid to all, and state that this is the conclusion, and after they're signing an agreement and release, that there would be no other claims. I did do that within the family, so I have documentation that everyone has agreed.
Okay, well, it sounds like you're right on top of it. So, once all the money is distributed out, the trust is basically terminated.
Appreciate that, Joe. Thank you very much.
All right, Ed, thank you. All right, let's go to John in Sarasota.
Hi there, I'm here.
John, we have maybe a minute. So,
okay. I have a 2-year lease. I've been living in this one house for 4 years, but the current owner's representative management company said that they were the owners were selling the house, and they are going to issue an order to vacate the property. Can they just terminate the lease and give us an order to vacate, and we have to get out within 30 days?
I'd have to see the lease to be able to answer that question. More than likely, when someone buys it, they also buy it, and they're stuck with your lease for the term of it. There might be special language
in the 10 months left.
Yeah, well, I would tell them if you want to leave, if you want to stay there, I would tell them you're going to fight that. You don't think they have the right to terminate the lease, but I'd have to see the lease before I could really give you a final answer on that.
All right, let me have your number personally, or can you call me back?
You can email me. You could email me the lease if you want, joe@attypip.com.
I wish I could get that. I'm an 80-year-old veteran, so I didn't get it very
I'm going to run out of time here. They'll put you on hold, and they'll give it to you off the air here.
Very good. Thank you.
All right. Thank you for listening to Ask an Attorney, all about Florida law. Be back live next week, same time, same station. So if you have a legal question, you remember where you can listen to Ask an Attorney, all about Florida law. You have a great week. So long.